Hey, it's Jordan. I am delighted to be joined by Judge Kevin Sharp. You're a former judge who now does a lot of legal work, particularly focused on mandatory minimum sentences. And you are currently the attorney for Leonard Peltier, who is a Native American who has been in prison for 46 years
Right.
from everything I know, a crime that there is no evidence that he ever committed. So we're going to get into all that, but I wanted to start with Leonard Peltier is 77 years old. He's not in great health, and he recently, a couple days ago, was diagnosed with COVID-19.
Right.
By his own account, the prison he is in Florida, the conditions have been horrendous, particularly during the COVID-19 pandemic. I know you don't really have a ton of updates, which is part of the story. Can you kind of talk about what you know of Leonard's condition as far as having COVID-19 now?
Yeah. So, it was, thanks for having me on. I appreciate it. One of the problems and one of our concerns was that because of Leonard's age and because of his health and because of the way the Omicron variant is running rampant through really the country, but in particular the prison system, we had a real concern that without strictly following CDC guidelines, Leonard was in danger. And our fears were kind of realized on Friday when we heard from him. And Leonard said, I really had a rough night last night, the Thursday night. Really a deep, persistent cough, feeling really, really poorly. And we were able to get him tested on Friday and got a confirmation that he was positive. After that, the information has kind of trickled out as to how he's doing. They put him in a medical unit isolation, still part of his housing unit. He's not been moved into medical, which is kind of a double-edged sword. It's good news that his condition is not serious enough, at least as they see it, to warrant putting him in more, in the medical unit itself. But it also means, is he getting the attention that he needs? After those kind of that information that trickled out for me on Saturday and a little bit on Sunday, then it's been kind of radio silent with them, blamed on the national lockdown because of an incident that happened at one of the facilities in Texas. And so I've kind of really been shut out, and I'm hopeful that he's okay. Part of the protocol would be if things turn serious, that they'll call me. So I guess the really good news is they haven't called me, but I hope that's because everything's okay and not because no one's paying attention.
And do I have it correct that even though he's been eligible for a while, he was not able to get the COVID booster shot, that third shot?
They have been eligible. He got his first two shots and should have gotten a booster in November. BOP has been slow to roll out booster shots. And so it's my understanding that some staff have gotten shots, but not by and large the population, and certainly not Leonard's unit.
Got it. And let me just start from backwards. I mean, there's a lot of people watching that know this story, but there's a whole lot of people that don't. In the 1970s, there was what they called the Reign of Terror going on against Native Americans. Wounded Knee was occupied for, I believe, 70 or so days. Leonard Peltier, who is he is a Lakota and Chippewa Native American from South Dakota. He was part of AIM, the American Indian Movement. Right. And in 1975, there was a gunfight at the Pine Ridge Native American Reservation in South Dakota, and two FBI agents were killed. And Leonard Peltier was prosecuted and convicted. There were three others that were prosecuted, but Leonard Peltier was the only one convicted. Can we go back? I know you were obviously not part of it then. You have become his lawyer now. But can we go back? Because it has come out since. You have witnesses being intimidated and coerced. You have evidence that would have proven his innocence that was withheld from his defense team. In Leonard Peltier's own words, he was not able to put up a defense. And I mean, you even have one of the key prosecutors who prosecuted him came out years later saying he should be freed. And there is no evidence that Leonard Peltier shot or killed at these agents.
Right.
Can you kind of just, for people that don't know the story, this is one of the most, I mean, obvious cases of prosecutorial abuse, FBI abuse. Break it down, all the things that went on.
Yeah. Let me start with this. And this happens a lot. Everybody talks about the two FBI agents that were killed in this shootout. There was also a young Indian boy named Joe Stuntz who was killed, shot in the head by an agent. Unclear exactly who shot him or why. And that was never investigated. So we don't know who killed Joe and why Joe was killed. Nevertheless, the shootout occurred in June of 1975, right? It's on the heels of the 1973 takeover at Wounded Knee. And originally 4 individuals were indicted for killing the agents. The one indictment was dropped, the one against a young man named Jimmy Eagle. And the prosecution went forward with Bob Robideau, Dino Butler, and Leonard Peltier. Now, Leonard, believing that he could not get a fair hearing in the United States, went to Canada. And the Canadians would not extradite him initially because there was not enough evidence that he had committed any crime. So Butler and Robideau were tried separately. During that trial, the judge let in evidence of the Reign of Terror, let in evidence of the misconduct that was occurring in and around the reservation. Also, the indictment had been obtained because of the testimony of 3 young boys who were up there. They were teenagers, and they had testified that they saw Leonard and the other 2 going down the hill to kill the agents. Turns out that testimony had been coerced and wasn't true. And during the trial of Robideau and Butler on the stand, one of those boys, Norman Brown, who's still alive today, and I've read about his story and gotten it firsthand from Norman. Norman, after swearing on a sacred pipe, realized that he could not stay with this story and that he needed to tell the truth. And the truth was he didn't see any of that, that when the shooting had started, Leonard had gathered those boys and told them to take the women and children to the other side of the hill to safety, which does 2 things. One, it tells you that there was no evidence that Leonard and his co-defendants went down the hill, but it also tells you that the shooting had started and Leonard was not part of it, because Leonard is on the hill with the boys and hears the shooting as they do. So Leonard did not instigate any of that, and he's not down the hill in a position where he could shoot anybody, much less shoot them at point blank range. Now, the judge in the Robideau Butler trial lets in this information, this testimony about the Reign of Terror and the misconduct, and Norman Brown changes his testimony to tell the truth and tells the court and the jury about the witness intimidation. Robideau and Butler are then acquitted based on self-defense. So now the U.S. attorney has got a problem. They're only left with one defendant. He's in Canada, and the testimony has changed. So there is an FBI memo that discusses using the full resources of the United States government into getting a conviction of Leonard Peltier. And one of the things that they do is get an affidavit from a woman named Myrtle Pourbaix. Myrtle Pourbaix testifies in the affidavit that she's Leonard's girlfriend. She was there that day. She saw Leonard kill these 2 agents. Obviously, that's going to be enough for the Canadians courts to say, okay, let's extradite him. But it turns out that Myrtle Pourbaix never met Leonard Peltier. She wasn't there that day. She didn't see any of this. That, as she later said, she signed that affidavit, which she did not draft because she had been threatened and intimidated, and they threatened to take her child away from her. She had a daughter that they had threatened to take away from her. Now, which we now know, and she knew then, is no idle threat, as we've learned from the revelation about these Indian boarding schools. Leonard, in fact, had been kidnapped. Leonard and his younger sister, who was 6, Leonard was 9 at the time, was literally ripped from his grandmother's arms and taken to one of these boarding schools. So, that was no idle threat. She signed the paper that they wanted to sign. But it was revealed before she testified that this affidavit had been was not true. She had signed 2 other affidavits that were inconsistent with that. And as the prosecutor later said, there was not one scintilla of truth in that affidavit.
Right.
But it didn't prevent the U.S. attorney from filing that with the courts, which in and of itself is an ethical violation and sanctionable conduct. But they've got Leonard back, and there's no remedy under the extradition treaties to return someone when you've obtained an extradition based on fraud, which is what it was. But the case is also transferred from Judge McManus to Judge Benson. And Judge Benson is in Fargo, North Dakota. He does not let in any evidence about the Reign of Terror. He does not let Leonard's attorneys question Myrtle Pourbaix about the intimidation that was forced on her. He does not let his attorneys question the boys about their prior perjured testimony. And
it's also my understanding, correct me if I'm wrong, that early on, one of the jurors had said that they were biased or had a predisposition against Native Americans or Leonard's race, I believe it was.
Right. That's right. It was one of the things as I'm going through studying this case myself before I ever decide to come in and take it on pro bono. On day 2 of trial, 3 women show up at the courthouse. They have nothing to do with the case, but they have a notarized document in their handwriting that says, we have something we want to tell the court. We can't live with ourselves if we don't let you know that one of your jurors works with us, and she told us that she's prejudiced against Indians. I'm using the terminology that they used and the terminology that Leonard uses. So the court calls each of the women in. They talk to them independently. The three women confirm that in a conversation with one of the jurors, she admitted she's prejudiced against Indians. She said to them, I may be called as a juror in this case of the Indian who killed the 2 agents. Never mind, you've already decided, you've got a conceived idea of what the verdict is, what's happened. But y'all know I'm prejudiced. They tell that to the court. The court says, well, wait a minute, let's talk to this juror. And you think the juror is going to say they misunderstood me or I never said that. And instead, she says, I did say it. That's true. And the court and Leonard's lawyers ask the question, well, okay, you're prejudiced, but can you still be fair? And she says, yeah, I can still be fair. and they leave her on. Now, today, that would never happen. She would be removed from the jury. Removed as one of the jurors. But at that time, she stayed.
Right.
There was also another big problem with the case, which is from a constitutional standpoint, which is that the government's big piece of evidence was a shell casing. In the shell casing, they said, not the best ballistics test to conduct. We wish we could do a firing pin test. That would be the most accurate and would tell us exactly which weapon. But a shell casing will tell us the type of weapon. And the type of weapon is the type of weapon that Leonard Peltier had. This is it. And there was a lot of waving of the shell casing around, and that was a big part of their closing argument. The ballistics expert said, I wasn't able to conduct any other tests. Turned out they learned years later they had conducted a firing pin test. And the firing pin test showed that it wasn't Leonard Peltier's weapon.
So they had conducted a direct ballistic test to trace the actual weapon of the bullets that went into these officers, and it wasn't his gun, but they withheld that evidence, which would have exculpatory evidence.
Exculpatory evidence, right? That's evidence that tends to show you didn't commit the offense that they say you committed. Inculpatory would be evidence that shows you did do it. So under the case of United States versus Brady, the Constitution requires them to turn over Brady evidence, was what we call Brady evidence, exculpatory evidence in their possession, and they simply didn't do it. So now they've got a big problem because their theory has been he shot them. And now it's been revealed that they knew he didn't shoot them. And so they changed their theory. Okay, well, our theory is no longer that he shot them. And they admit, and do today as they have to, they don't know who killed the agents. Their theory became one of aiding and abetting. He was there, he was shooting. We don't have any proof that he hit anything, but he was there. And so he's an aider and abetter. We don't have to show that it was his weapon. And so the verdict still stands. At that time, the standard of review was, well, would the jury probably have made a different decision had they had the exculpatory evidence? And the Court of Appeals said, we can't say that they probably would have made another decision. They possibly would have, but we can't say probably. Verdict stands. That's not the standard today. Standard today would be, in the absence of that evidence, did he nevertheless get a fair trial? And that becomes an easy one. Absolutely not. He didn't get a fair trial.
But also, what is aiding and abet? What does that even mean? Because if their standard is he was there, he was aiding and abetting, couldn't that be said for anybody that was there at this gunfight?
Absolutely. Absolutely. But then the question is, who did he aid and abet? Because his co-defendants were acquitted based on self-defense. So there was no crime. Who did he aid and abet? Now, the assistant U.S. attorney was asked that question years later by Steve Croft in a 60 Minutes interview, and he said, I don't know, maybe himself. Well, that's impossible. You cannot aid and abet yourself. So why are we still here? And the Court of Appeals asked the prosecutor during oral argument, well, wait, if aiding and abetting had been your theory that you argued at the time, and that had been the theory under which he was sentenced, wouldn't the sentence have been different, not 2 life sentences? And they acknowledged, yes, probably so. But nevertheless, by upholding the original conviction, the sentence stands, and Leonard Peltier, who there's no proof that he killed these agents, sits in a prison cell for 46 years.
And isn't it, correct me if I'm wrong, I'm certainly no lawyer, isn't it legally that the prosecution has to provide the defense with evidence that could be used to exonerate somebody?
Yeah, right. They do. And that's why having the different standards make a difference. By not giving him that evidence, that exculpatory evidence, which is required under the Constitution, he was deprived of a fair trial. But that wasn't the standard then, right? This is it gets kind of hard because we think of this in terms of our present day knowledge of how these court proceedings ought to go, not the 1970s version.
Right.
And the 1970s, there was a different idea about law enforcement. There was a different idea about prosecutors. There was a different idea about the court system. And, one of the reasons and one of the things that led me to take on this case was my own personal background of having taken multiple times oaths to support and defend the Constitution. It's important to me. I did it when I joined the Navy out of high school. I did it when I passed the bar and became a licensed lawyer in the state of Tennessee. I did it again when I went to work for Congress in the 1990s. And I did it when I joined the federal judiciary. I'm swearing to support and defend the Constitution of the United States. They took that same oath. But for them, getting a conviction was more important than their oath.
And I want to also
wrong.
I want to also point out that the original U.S. attorney who prosecuted Leonard Peltier, he has come out since then, asking for Leonard Peltier to be freed. This was
Right.
James Reynolds.
Right.
James Reynolds was the U.S. attorney, and he wrote to President, let me make sure, to Biden in July of
Right.
last year. Quote, "I write today from a position rare for a former prosecutor to beseech you to commute the sentence of a man who I helped put behind bars. With time and the benefit of hindsight, I have realized that the prosecution and continued incarceration of Mr. Peltier was and is unjust. We were not able to prove that Mr. Peltier personally committed any offense on the Pine Ridge Reservation." I mean, that's, I mean, I'm not a legal reporter, but I know enough. It's pretty rare to get prosecutors to come out and basically been like, yeah, we didn't have it. Please free this man.
Right.
What are your response to
I
that?
mean, right. You don't have to be a legal scholar, or a legal reporter. You have to be a human being, and you can see the concern that comes off the page from this prosecutor. He didn't try the case, but he was there as the supervising U.S. attorney for appeals, post-trial motions, sentencing, the habeas corpus petitions that were later filed. He was there for all of that. He now knows, looking back, that what they did was wrong, that it became a convict at any cost. And earlier in another document, he said, we cut corners. Well, that's an understatement. That's the understatement. They violated the Constitution is what happened. And he wouldn't necessarily have known that at the time, because he may not know what the AUSAs, the assistant U.S. attorneys, are doing in this case, or what they had done before he became the U.S. attorney. But he's learned it. And now that he knows it, he's beseeching the President of the United States to fix this, fix what he helped create. Let's end this and begin the healing of the government's relationship with the Native Americans. This is a bigger story than just this one individual.
Right. And I also, obviously, you're not a historian, but we should make sure we point out all of this was going on under the timeline of Cointelpro.
Right.
I might be mispronouncing, but Cointelpro was, the FBI, frankly, in concert with the judicial system, surveilling, infiltrating, disrupting, spying on the civil rights movement, the American Indian movement. They did it to Martin Luther King. They certainly did it with the AIM movement. So when you see, all right, these two other defendants got off for self-defense, the third one also, I don't know if it was self-defense, but was not convicted.
Correct.
The FBI was hell-bent on somebody's got to go down for this, and that was under the context of Cointelpro.
So right, and that program started by the Hoover FBI was discovered in I believe 1973, and the Church Committee in the Senate was investigating that. Now the FBI said, well, we have shut it down. They recognized that it was unconstitutional to engage in domestic spying and counterintelligence, which is what COINTELPRO stands for. It's counterintelligence program. To engage in counterintelligence about organizations and people that they believed to be subversive to the government. What they were doing was protesting the government. Right. So they were using that program to run counterintelligence against our own citizens. Now they say once they are discovered that they shut it down. The tactics, though, continued. And you see those tactics happening on Pine Ridge Reservation at the time, even though, supposedly it had been shut down for 2 years. The evidence would show you that that's not the case. Right. And they were still running counterintelligence against, you're right, Martin Luther King, Black Panthers, unions. They did it with trade unions. They believed those to be subversive to the government. They did it with various other political parties, not the mainstream political parties. So, that's part of this history. And that's part of the additional reason why Leonard needs to be freed. he's a remnant of that time that hopefully no longer exists, except to the extent that we still imprison people who were victims of it.
Right.
Let's move beyond. The FBI needs to cut from J. Edgar Hoover. It's hard to believe that we're in 2022 and we're still talking about removing ourselves from J. Edgar Hoover.
Well,
but
also,
his fingerprints still exist.
I'll just point out it might have had a different shade, but I was at Standing Rock for 6 months on and off. There was FBI and Department of Homeland Security infiltrating the Standing Rock movement too, and putting in infiltrators and moles. So it might not be as prevalent as it was in the 70s, but it certainly has still some remnants of the U.S. Government, FBI, DHS, U.S. Marshals. They were working to infiltrate the protest movement at Standing Rock. Let me just give my audience so they could see. Right now, the change.org petition has over 40,000 signatures to free Leonard Peltier. You also have leaders of the National Caucus of Native American state legislators who wrote to President Biden on Monday urging him to release Leonard Peltier. They said, Mr. President, do what is right. You have Senator Brian Schatz of Hawaii. He's the chair of the Senate Indian Affairs Committee on Wednesday of last week, urged the president to commute Peltier's prison sentence. He said, quote, I commend your administration's commitment to righting past wrongs in our criminal justice system. In continuing that work, as you consider recommendations for individuals to receive clemency, I write to urge you to grant a commutation of Leonard Peltier's sentence. And in October of last year, you had Congressman Raul Grijalva, as well as 10 other House Democrats, urged the president and Attorney General Merrick Garland to expedite Peltier's release. So you really have a groundswell now, whether it be that he has COVID as the latest, kind of precipitator. But could you kind of talk about the momentum now to free him?
Yeah. The name you didn't mention was Patrick Leahy. The longest serving U.S. senator came out in support of clemency for Leonard Peltier. And it's funny, it had nothing to do with any effort of ours beyond getting the word out. But Danny DeVito started tweeting yesterday, and last time I looked, he had like 50,000 likes to this tweet of, it's time, Mr. President, to free Leonard Peltier. I think a couple of things are coming together here. That the Native American voice that had been ignored for centuries, and not just ignored, but actively stamped down, has come to the surface and come to the mainstream. People are starting to recognize the mistreatment by the government of the Native Americans that were here, and this is something that now is being viewed in the mainstream. We're starting to see in the mainstream, by mainstream American, the problems with the Indian boarding schools and what happened there. We have a Secretary of the Interior for the first time, Indigenous person, as Secretary of the Interior. All of those things are coming together at this time and raising awareness again to Leonard, who is not just this one guy who was railroaded in 1977, in a 1977 trial. He's really the face of what's wrong and what's been wrong with this relationship between the United States government and the Native community that was here. Right. And James Reynolds' letter recognizes some of that. All of those things are coming together. The time is now to do that. And you put on top of that Leonard's age and poor health and COVID running through the system, the urgency has also percolated to the surface. It's time to end this.
Right. And I would also point out, you have the prosecutor was a part of going after him, saying we had no evidence. You have all of this new revelations that have come out over the last few decades showing coercion, intimidation, constitutional violations. In my view, Leonard Peltier is not only entitled to clemency and to be freed, but restitution for losing 46 years of his life. Your thoughts?
Well, let's get him out and and see what the other options are. The most important thing for me right now, and that it's really the first time that I've really thought about that. The important thing right now is let's get Leonard home. He's got children, grandchildren, great grandchildren, and the Turtle Mountain Band of Chippewa are ready to embrace him and take care of him as an elder. Let's do that. Let's get that done. And Mr. President has the absolute ability and authority under the Constitution to sign that paper and end this today. And let's move on.
With the current groundswell, I listed off all of the Congress folks, as well as just activists that have been fighting for this for years, including Native Americans first and foremost.
Right.
Are you seeing any response or tea leaves from the Biden administration that they're even listening to these calls?
I think they're listening. I don't know. I don't know what they're saying in response to what they're hearing, but they are hearing about it. And someone asked about it in a press conference last week, and it comes up from time to time in the White House press corps. And it's being talked about internationally. The Amnesty International is on this. The UN has taken another look at it. So it's impossible for them to ignore it. What they're saying in there, I don't know. I'm hopeful that they're saying the same things that we heard on the campaign trail, which is this is going to be a different world. This is going to be a different criminal justice system. This is going to be a compassionate administration. And so I'm hopeful that's what they're talking about, and talking about a timeline for getting Leonard home.
Right. Thank you, former Judge Kevin Sharp, who's now representing Leonard Peltier. I hope you get word today on, if he's getting any better, getting any worse. That's part of the problem. People don't realize when you're dealing with prisoners, there's seems to be a significant delay in learning details of their health.
Yeah, right.
Thank you for taking the time and for what you're doing.
Yeah, thank you. Thanks for having me. Thanks for letting me talk about these really important issues, not just to Leonard, but to the nation. It's important.
Thanks for watching, and make sure to tune in to Status Coup's daily live stream Monday through Thursday at 5 o'clock Eastern Time and Fridays at 4 o'clock Eastern Time.